Okay, Danielle Free. Miss Free, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On November 6, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it speeding 55 miles per hour in a 40-mile-per-hour zone in the 7800 block of Spencer Highway. Upon contact with the defendant, the officer detected an odor of an alcoholic beverage on the defendant's breath, and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4. The defendant admitted to drinking and to taking prescription muscle relaxers on occasion. The officer located a case of twisted teas in the defendant's motor vehicle with 2 open cans of twisted teas, 1 in each cup holder. And
Consuming while driving?
There were 2 open cans in the cup holders, yes, Your Honor. And DICs were read and the defendant consented to blood.
Ms. Free, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you not to drive. Do you understand? You are not allowed to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I'm also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you consume alcohol, illegal drugs, unprescribed controlled medication, likewise, you will go to jail. No more PR bonds. Do you understand? Any prior DWIs, Alex?
No, Your Honor.
Any prior criminal history at all?
He has a prior racing on a highway that was dismissed earlier this year.
What do you do for a living, Ms. Free? Why?
I just graduated nursing school, so I was a CNA and caregiver for in an independent care facility. But right now I help take care of my great grandma, so it's just a lot at once.
So how do you support yourself? How do you eat?
I live with my grandparents and I help them take care of her. She can't take care of herself. She has dementia and a mental disorder.
I'll fill out an application for you. I need to know everything about you, how much money you make, what kind of car you drive, any source of income that you have, money in the bank, stocks, bonds, IRAs. I'll have you fill out an application, but I need to know everything about you. Don't just put zeros because I'm going to send it right back to you.
Yes.
Do you understand? And I'll see whether you qualify. Above all else, do not drive. Do you understand? There's no justification that you can give for getting in a car. Likewise, don't consume alcohol or drugs. If you have a problem, you better address it, because if you don't, I'm going to do it for you. Promise you're not going to like the way that I do it. You understand? Okay. Do you mind giving me an application, please? Good morning, Ms. Furlow. Ma'am, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. Okay. Officers were dispatched to a residence in Harris County, Texas, in response to a disturbance. The complainant stated they were in their car and backing out of their driveway when the defendant parked behind them. The defendant then got out of her car and started banging on the complainant's vehicle while shouting obscenities and threats. The defendant also tried to gain entry into the complainant's vehicle. Specifically, the defendant stated she was going to whoop their ass, and the complainant stated they were in fear for their lives during the incident. The officers discovered the defendant is a coworker of one of the complainant's family members.
Owner, boss.
So the threat is what?
The threat is she was banging on the door and said, "I'll whoop your ass."
I have it on camera.
Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons, okay?
I-
What do you do for a living, ma'am?
I own a fleet company, 3 trucks, and they're my drivers for the road. We are drivers.
Okay,
So they just basically stole my vehicles.
we are going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign and reset. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, okay?
Okay, but I move out of state next month, so I just talked to them about.
We'll have you sign a reset, and then we'll just take a seat while we get your bond conditions. We'll have you sign the bond conditions, and then you'll be free to go. Okay, please. Can you bring them over?
Sir. Mr. Rios, to come forward. Right there.
You don't have the heater on, do you?
No.
Please, please, no heater. Thank you so much for coming.
Yes, sir.
What is the gentleman's name?
I know the first name is Rico.
Oh, is it Gideon?
Yeah.
Are you Mr. Gideon? Shh. Mr. Gideon?
Yes.
Good morning, sir. Mr. Gideon, you are charged with assault of a family member. Do you understand the charge against you? You are facing a year in jail and/or a $4,000 fine. We need to do probable cause. I need to find out what happened. So we're going to do that real quick. You have the right to remain silent. Anything you say can or will be used against you.
Okay.
Is he okay to understand everything? Yeah? Okay. All right. So we're going to do that real quick. We'll find out what happened, okay?
Yes, Judge.
Okay, go slow, Alex, please. No. Stay here. Stay here. Stay here. We need to just find out what happened.
Yes, Judge. The complainant and the defendant are mother and son. The officers were dispatched to apartments in Harris County, Texas, in response to a family disturbance. The complainant told the officers that the defendant is diagnosed with mental disabilities and that he is known to wander away from the residence. The defendant was upset because he was not being allowed to leave and grabbed the complainant on the forearm, squeezing it with full strength and causing scratches, bleeding, and pain.
Is mom here?
She was, he asked her.
I just asked her, said she wasn't properly dressed for court, so.
Yes.
Can you bring her in, please?
Yes, if she, I went out there a few weeks ago, I didn't see her.
It's okay. Hopefully we can find her. Mind just hanging out with us? I'd like to wait until mom comes. So we
She left.
left all the way? Do you want to call her?
So I think she left.
Do you want to call to see if she's, you can use it here. That's fine. Just call her.
Okay, Judge, while you're doing that, can you take a look at page 38, Johnson? We need a bond set.
They're not coming to get her? It's an ag assault.
If we give her a bond, then they'll issue
50,000. But, I mean,
She's not even announcing.
41.
I'm sorry, she's not even announcing.
do you think she'll come back? I mean, we can wait. There's no rush. If you want to just like,
Step outside. I need-
sure, take your time, but just don't leave though, because I want to give you guys a lawyer and I want to talk about how to go forward. And I'd like to talk to
Right here, and I'm gonna go out and.
or right over there, just wherever you want, but don't leave, guys, okay?
I know.
Okay. Yeah, take your time, no rush. Hi.
Oh, hi.
Thank you so much for coming. I appreciate it. You're the complaining witness in this case. So you obviously know what happened. We've done probable cause. I think that there is enough probable cause to go forward.
He has autism
Correct.
and sometimes he have behaviors. And so that's what happened. And the only thing,
I don't want to talk about the case because in an effort to protect him, I've got a bunch of DAs here and everything you say, they can use it against him to prove punishment and guilt. So I don't want to do that. I can give you a lawyer today and we can go forward and try to figure out how to go forward. Whenever I have these types of cases, I usually order, no contact or no threatening or harassing. I don't want to do anything yet. What I'd like you to do, if you don't mind, talk to Lori. I'd like to appoint her on your case and then we can figure out how to go forward. I'll give you anything you need, if you need any resources, just let us know. We can try to help you out as much as we can, Okay, Lori, do you mind?
Have a seat and I'll come and talk to you.
okay.
So just thank you so much for coming. We'll try to help you out, okay? Of course. Thank you. You are Oscar Martinez. Mr. Martinez, you're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. Officers were dispatched to a residence in Harris County, Texas, where the complainant told the officers that the night before, his mom heard a crash outside their house, but did not go outside. The following day, the complainant went outside and saw that his vehicle, which was parked on the street, had been hit. The complainant followed the tire marks and debris to a house approximately 400 feet away, where he observed the defendant's vehicle with visible damage. The officers arrived and observed blue paint transfer from the complainant's vehicle to the defendant's. The officers spoke to the defendant, who said he had no recollection of striking the complainant's vehicle, but admitted to have drinking approximately 6 beers the night before.
Right? You've got A, you've got C, but you don't have B. How do we know it was him?
Your Honor, the connection would be the blue paint.
I understand. How do you put him driving the car? How do we know it wasn't Meemaw,
Let me check the.
Peepaw?
I'll check the OR if there's any further information.
Martinez.
Sagara,
It's an FSGI. Don't say anything. Are you losing?
Sorry, what was it? Yes,
So Judge, the defendant admitted to driving at the time that the car was being struck. He admitted that he was driving home from a party at that time. He said,
Alex didn't say that.
That was in the.
right, it's in the OR, Judge, it's not in the evidence, but that's what the officer
Give me,
was-
does he admit to the accident?
He does not. He says that he was driving, he does admit to driving home at the time that the car was struck, but he says he doesn't know about anybody being struck, but he just admits to drinking at the time of the accident.
We don't work on hunches, man. We don't. I need more than just a hunch.
It's not a hunch, argument's not it's not a hunch. He's admitting to driving at the time.
He admits to driving at the time, but doesn't admit to the accident, doesn't admit to anything like that. All he says is, I'm driving at the time.
Well, Judge, based off of the nature of the accident, the extremity of the accident, the pain transfer of the car, the state's position is that there'd be no way that this defendant could not have known that there was an accident at the time.
I don't know. I'm sorry. I'm gonna find no probable cause. I mean, if you get something else later, let me know. But at this point, be careful, Mr. Martinez. You know what I mean? You've got one life. You're drinking, driving. We lead the nation in DWI fatalities. Lead the nation.
Yes, sir.
Where's my phone? $10 on a click. $20 will get you anywhere you want to go in this city. You know what I mean? Use it. All right. I'm finding no probable cause. Just take a seat for me momentarily, sir. Good morning, Mr. Bayo.
Morning.
Mr. Bayo, you're charged with assault of a family member.
Yes.
You're facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
Officers were dispatched to an apartment in Harris County, Texas, in response to a family disturbance. The complainant told the officers that he lives in the apartment with his ex-wife and her current boyfriend, the defendant. The complainant and ex-wife began arguing about money when the defendant became involved and punched the complainant with a closed fist 2 to 3 times, causing pain. The officer observed bruising on the complainant's face and a cut on his lip. The defendant told the officers that the complainant threatened to hit him first, but admitted to punching the complainant.
Hey, you always come up here, Lauren.
I'm sorry,
You always come up here on these cases.
just in case you have any questions, Judge.
So what is the relation?
The relationship is,
So I believe that the defendant is dating the complainant's ex-wife. So the defendant and the complainant are not related, but it's just the ex-wife. I guess.
Do we know if she wants to have, contact with him? Do you know anything?
So from what I understand, because our back tried to reach out, they all share a phone.
3 people sharing one phone.
That is what, according to our back. So I called and I was able to get a hold of the ex-wife who gave me the number, another number for like the complainant's business, I think his business phone maybe. I tried to call, they just left a voicemail, I wasn't able to get in touch with them. So I'm not really sure entirely about like contact between all of them, but I know they're all living together.
Okay. So I'm going to order, until I know that she wants to have contact, I'm ordering you not to have contact with this person. Mr. Bayo, I'm going to find that there's probable cause to go forward with the case. Any alcohol or dope as an allegation in this?
no, Your Honor, there's no allegations about it.
Okay. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. I like to follow the wishes of the complaining witnesses, and I don't know if she wants to have contact with you or not. So until I know, don't have contact with her. There is a protective order in place. You need to get to know it, because if you violate the protective order, the state can and will file additional charges against you, and things will go sideways real quick. Do you understand?
If I may, the complaining witness is a man. It's his, he's currently dating the complainant's ex-wife. So
Yes.
it's a male.
Yes, so the female is not the complainant
Yes.
in this case.
Okay, it's the male.
Yes.
Got it. Regardless, I don't want contact. I don't care what gender, sex, color, creed, doesn't mean, nothing matters. My only concern is public safety. That's all I care about. You endanger any person, place, thing, whatever. There's only one place that we have for you. Do you understand?
Understood.
How old are you, sir?
Wait,
What do you do for a living?
right, she flew me out here from Maui. I was working over there at an electrical supply company. I did UPS stock transfers at the end of the day.
So you have an income.
I did have an income. Currently, I'm not working.
Why?
I'm waiting for my ID to get shipped here, my hard copy. My paper ID just expired this month on the 11th.
So did you stop working? How have you been working? You stopped recently?
I stopped in Maui, unemployed here when I arrived. I came here to help her with her 2 daughters, fraternal twins who are just making 2 this month as well. She's having troubles with her ex-husband. He has a past mental history, health history with schizophrenia. She says he
I don't want to talk about the
Yes,
case.
yes, yes.
My only concern is that whether you can afford a lawyer or not.
no, I cannot afford a lawyer.
Okay, I want you to understand that there are a bunch of restrictions on here. One of the restriction is a residential restriction. You're not allowed to go back to this house for the time being. I will appoint your lawyer now so that we can get more of your side to see how we go forward. But don't pick up any new cases. Don't violate these conditions. You got to understand, you got out because we gave you a free bond. You violate conditions, I'm going to put you in there. You'll have a $5,000 to $10,000 bond. And if you don't have anyone to put up that kind of money, you will be stuck in there for the next, could be 9 months. It takes 9 months just to get a 911 tape. So when you're out in the free world, think before you act, think before you speak. Because if you do it wrong, you may be with us for a long time. You understand?
Safe.
I need you to fill out an application for an appointed lawyer. Stephen is going to give an application. We'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box. Do not leave until you sign all our bond conditions. Otherwise, I'll issue a warrant. Do you understand, Mr. Bynum?
Yes.
Okay.
All right, Judge, next is letters.
Mendoza, Your Honor.
Thanks. Miguel Angel? Yeah. Are you Miguel Mendoza? Mr. Mendoza, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On November 6th, 2024, the officer was flagged down by a citizen stating they observed the defendant on the feeder road of South Houston Parkway operating a motor vehicle while hanging out of the window, swerving, and then drove over the curb and came to a stop in the grass.
Did you say he was hanging out of a window?
Yes, the witness observed him hanging out the window.
The driver?
Yes, Your Honor. And the witness advised that the defendant exited the vehicle, threw himself to the ground, began behaving erratically, was having difficulty breathing, was in a panic, was panting, and repeatedly would tighten to a fetal position and then would straighten out. The defendant advised the officers and EMS that he had consumed cocaine prior to driving. The officer observed the defendant with red, bloodshot eyes, had difficulty forming words when speaking, was unable to stand on his own, was in a panic, and was behaving erratically. Standard field sobriety tests were not administered due to the defendant being unable to stand on his own and had to be transported. A blood warrant was signed and executed.
You don't have the results yet, do you? That's not cocaine. That's something else. Mr. Mendoza, I'm going to find that there's probable cause to go forward with the case. I'm now sending you for a drug test. You were to go take a test and then you're to come right back. Do you understand? If you fail to take the test, if you fail to come back, I'm going to revoke your bond. I will put you in jail. You will not get any more PR bonds. Do you understand? Do you have a valid Texas driver license? Run his license, please.
Yes.
Do you have liability insurance in your name? I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you have a problem with drugs or alcohol, I'm giving you the opportunity to address it yourself now because you're on bond. If I see that it becomes a problem, we're going to do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Your Honor, his license is eligible.
Any priority to be eyes?
No, Your Honor.
Okay. I want to send him for a test. You come back and then we'll talk about your lawyer situation.
Go ahead and just write out your phone number.
Hey, will you reach out to your lawyer? Reach out to your lawyer. Yeah. I want to talk to him. Yeah. Try to reach out to him, will you?
I'll write your phone number.
You're fine. You're doing good. Stay. I need to talk to him. Go reach out to him, please. Felicia. Note the results. Positive for coke. Here.
And I went ahead and had him write your phone number so you can give it to.
I'm chatting you his phone number here.
2, 8.
So Mr. Mendoza tested positive for cocaine.
Okay, is he on bond right now, or I guess he's out, okay, is this his
He's on
first
bond
setting?
for now.
Okay, is this his first setting, or,
Look at me. The dope stops now. Do you understand? You test positive for cocaine, marijuana, anything else anymore, I'm going to put you in jail and I'm going to make your bond. Do you understand? If you cannot stop, I will have a contempt hearing, hold you in contempt, slap you with 180 days, probate it for 2 years, and put you in a rehab facility. Do you understand?
Yes,
I am giving you the opportunity to stop using now. If I find that you're using, I don't care what you come up here and try to explain to me. I've got a prescription from England that tells me that I need to use cocaine. I don't give a rat's behind what your excuse is. You use, you will stay with me. Do you understand?
Yes, Your Honor.
Do you know if Mr. Mendoza has a Texas driver license? Mr. Mendoza, this is an affidavit. This is an affidavit that you're going to sign with me today, promising me that you're not going to use marijuana, cocaine, methamphetamine, any illegal drug or unprescribed controlled medication. Do you understand?
Yes, Your Honor.
And giving you a lawyer, it is your responsibility to stay in touch with him. I am now going to test you at least 2 times a week so that I know that you're not using. Cocaine stays in your system about 3 to 4 days. So I'm going to test you at least 2 times a week so that I know that you're not using. And the next time you test, you will stay with me.
Sure.
Do you understand?
Yes, Your Honor.
Okay. I'll have you come up here, swear test that you're not going to use. I'm going to have you get a Victoria sign and reset. We'll get you with Fleischer for your bond conditions. And then as soon as you step out of here, we're going to have you talk with Hugh. And then I will see you back here on Monday to take another test.
Thank
All
you,
right?
Your Honor.
Good luck to you, Mr. Mendoza.
Allow me not searching here up front. Yes, sir. No, sir.
Good morning, sir.
Good morning.
You guys have worked out an agreement where they're offering you 3 days in jail, credit for the 1 day that you've done. Why would we do this? You had one just dismissed not too long ago. Why would we give you another gift?
I think I've learned my lesson.
How? How have you learned your lesson?
Like, just the fact that I don't want to like end up in jail or anything like that.
Oh, you've learned your lesson. Really? The thing is that when we are too nice to people, they end up wrapping their car around a pole the following week. You just had one dismissed. Was it due to a PTI?
Yes, it was, Judge.
You didn't learn a damn thing because now you're back with another DWI. And you want me to take this time served so you can go around again? How have you learned any possible thing, Mr. Lara? Tell me. What have you done differently from the first DWI to the DWI you have done now to show me that you've learned something? What have you done? I want you to understand one thing, sir, is that you now are building yourself a house with the priors that you have. At some point, that house is going to crack, cave, and your ass is going to fall through. From now on, you will now be looking at a minimum of 30 days in jail. The proverbial slap on the wrist is gone, because now, as a matter of fact, with your priors, you're looking at a minimum of 90 days in jail for anything that you pick up from now on. You will also now be required to pay the fines, fees, and surcharges with this case. And I'm going to tell you, if you don't, every $100 that you owe, you will sit in jail for 1 day. You now will have around $4,000 in surcharges that you will be responsible for. And if you don't, there's going to be a heavy, heavy toll to pay. One way or the other, we are going to reach you, Mr. Lara. And if it's kicking and screaming you, dragging you into jail, all we want are our streets to be safe. That's all we want. Do you understand?
Yes, sir.
No more games. Even if you have a sip of alcohol, a sip of wine, you should not get into a car, because with your record, you get pulled over. Do you understand me?
Yes, sir.
How much are the fines and surcharges? Is it above a 0.15? What is it?
Yes, sir. It's for the current case, it is a 0.092.
It's a 0.09?
Yes.
I want you to understand that you're going to pay a very hefty fine fees. If it's above a 0.15, it's $4,500 in surcharges, not to mention the court cost. Now it's below a 0.15, so you're paying $3,000 on the surcharge. I'm going to require you to pay also the court costs as well. When you pick up a second DWI, it's a $6,000 surcharge, not to mention all the court costs. So get ready. Not only is it a minimum of 90 days next time, but you're looking at around court costs and fines and fees and around $7,000. How much money have you paid surrounding all this, when all it could have done is one click on your phone? $20. It's a geographical oddity. Don't matter where you want to go with your Uber, $20. Anywhere you want to go. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, there's no coming back. Do you understand? It will go on your record. It's going to be there for the rest of your life. It's even there after you die. And I'm telling you, Mr. Lara, you get pulled over and even have the faintest, funkiest smell of anything, you're going to be right back with us. And I'm going to tell you, I have jurisdiction over you for the next 5 years. Do you understand? You come back, it's not going to go well.
Yes, sir.
Get a clue. Hit a button. How do you plead to the offense? Guilty or not guilty? How much of the court cost? You will be required to pay $3,420. I will give you time to pay it, because we're not here to break your bank. But I want you to understand that we mean business. And the way that we do it is this way. If you don't pay $100, for every $100 that you owe, it is 1 day in jail. So you can imagine on $3,500 how much time you'll be doing. You understand? All right. Good luck to you. I'm suspending his license for 6 months as well, 180 days. All right, Eddie.
Yes, sir, Judge.
Get your boy, man.
Singleton, Your Honor.
All right. Morning, Mr. Singleton.
Good morning, sir. How are you?
Doing great. You know, it's Thursday, Friday Eve. Ready for the weekend, you know?
Yes, sir.
So,
See, you have the decorations.
thanks. Well, it's all them.
Yes, sir.
Your lawyer has asked for me, or is asking for a bond reduction in your case, but, my concern, and I guess my very, very primary concern, is public safety. You've got a lot of serious charges, and from what I see, your bond is now at around 200,000. You've got 2 open aggravated assault cases, and you got an assault of a family member with us. Our bond is set at 5,002. what did you guys want?
Possibly looking for a PR bond, due to the fact that his other two cases are extremely high. We believe that he should be able to bond out on that. He has been in talks with some family members regarding possibly coming up with money for the other two bonds, but reducing it, he would possibly help him out regarding the overall amount that he will have to come up with.
Well, so my concern is it looks like in September, he had an aggravated assault with a deadly weapon dismissed, right?
I believe that case got filed twice, and they.
So what's going on with the cases upstairs? And is it the same complaining witness as our case?
So there's two complaining witnesses on those cases, Judge. And it looks as though it's a different complainant with us.
Is there a weapon involved? Is it a shooting?
On the aggravated assault with a deadly weapon, Judge, so in the felony cases, there's two weapons involved, a machete and a gun, a 9mm handgun.
Does he shoot at them? Does he shoot?
He points at them. So the state would be opposed to lowering bond, Judge, given the severity and the propensity to violence that felony cases also show.
Oh, I think I remember this case. It's about a neighbor, and it's either about like a fence or it's about some bushes or some.
So the state's concern is community safety, Judge. So for those reasons, we would be opposed to lowering his bond.
Even if it's not going totally to a PR, if it's possible to do 2,500, that would be.
I don't know, I mean, we gave you a PR bond in this case. I let you out, right? And then you go out, you allegedly have these now two aggravated assault cases where in one, you point a gun at someone.
Shoot them in the head.
And if I remember, it's something so trivial over. Don't talk about the cases though, because I don't want you to.
I wouldn't incriminate myself or anything, but I live by truth, sir. And these people stole stuff from me.
No.
But, Mr. Singleton,
Not that.
there's a certain way when someone takes something from you, there's a certain way that you got to act.
I'm the one that
No.
called the police, Your Honor.
And that may be so, but there's still a certain way to act, right? And if you.
Washington?
Refresh my memory because I just don't remember it.
I can read.
Yeah, go for it. Just a brief synopsis.
On or about September 7th, 2024, complainant Sarver was his truck when he was a local fire department knocked on the window with a 9mm handgun. The defendant then pointed the gun at complainant Sarver and demanded that the complainant get out of the car. When complainant Sarver got out of the car, the defendant stated that he would shoot the complainant in the head. Complainant Sarver advised that prior to coming home from work and having his incident with the defendant, the complainant too was also involved in an altercation with the defendant earlier in the night. The second complainant stated that an altercation arose between him and the defendant, which resulted in the defendant punching the second complainant in the face, causing him pain. The second complainant punched the defendant back and the defendant ran to his house. Shortly after, the defendant returned with a machete in one hand and a stick in the other and was calling out for the second complainant to come out to the street. So it seems as though he pointed a gun at complainant one, and then in complainant two, he punched him, and then when the complainant punched him back, he came back with a machete and a stick.
Sorry, Mr. Singleton, it's just too dangerous for me, man. I can't give you a PR bond. I already gave you a PR bond. We let you out, and then you pick up these two serious cases. If we give you a PR bond now, if we were to lower, I mean, what's going to happen? You're going to pick up a fourth case? We're trying to prevent that from happening,
Order in court. Speak.
But not about the cases, okay? Just because I don't want you to hurt yourself,
I understand, Your Honor, but I don't recall you ever giving me a PR bond, sir.
We gave you a PR bond in our case, we gave it to you on 8/12 of 24. I gave you a PR bond. We let you out of jail. You know, you had certain conditions that you're supposed to follow, no weapons, no contact with the complaining witnesses. And so here we are with two very serious cases. If you're able to bond out and if you have someone, come back, talk, perhaps we can,
My fiance,
you know, but
the person who this is.
you're your own worst enemy, Mr. Singleton, really. I mean,
I'm
you're your
sorry.
own worst enemy.
I guess it's the military.
Well, don't blame it on the military. They're choices, right? And
Yes.
sometimes choices are made such that
I know I need help, Your Honor. I'm not saying I don't need help. However,
the problem is that you can't do that after the fact.
I
You
understand.
got to recognize it before the fact, before it balloons out of control. That's why, you know, and it's not our first rodeo here with you. You've had prior assaultive cases like this. So you have to understand that when you get these feelings, these urges that you're going to lose, you got to try to take care of this beforehand. Now, why don't we have him TRAS'd? Okay, let's see what it says. Let's see how to go forward. You know, if they say that there's treatment that's, you know, I have options available to help you with these issues. And I'm willing to help you and I want to. Yeah, we will do it. But the first things first is I got to have you evaluated to see how we go forward. And if you let me do this, and if you're honest with me, Mr. Singleton, let's try to work something.
I will be.
All right. Can you set up a TRAS for Mr. Singleton? Yeah, please. I'm going to set you for an evaluation. I'm going to have you speak to clinicians. Be honest.
I will.
We'll come back in a couple days. Today's what, Thursday? Come back on Tuesday. Let's talk about how we go forward. Okay?
Yeah.
Look, this isn't the be all end all, but let's see how we go forward. You know, that's why God put eyes in the front. So we go forward. We don't go backwards. All
Yes,
right?
Your Honor.
Okay. All right.
Thank you. Appreciate it.
Stay.